Now, in 2015, Graham Dwyer was sentenced to life for the murder of Elaine O'Hara. He is now appealing the verdict and still claims his innocence to this day.
And of course, our thoughts are with the family of Elaine O'Hara, who have to go through this all over again. Joining us to discuss Dwyer's appeal is criminologist and lecturer in forensic psychology, John Deane-O'Keefe. It's so lovely to have you here, John.
Thank you.
Of course, we're thinking about his family as well, who have to go through all of this. So he was sentenced and sent to prison in 2015 for the murder of Elaine O'Hara. How are we back talking about Graham Dwyer?
Well, he was sentenced in 2015 and everybody thought that was probably the end of it. But in fact, what it all boils down to now and where it's all come to is this thing called data retention. So what can you do with people's data? What can't you do with it? Which is, by the way, is a complex enough area anyway, and not for this programme or indeed any programme, to be honest. So that is quite complex. So just if I could just maybe net it down, maybe give some shape in it. So we had an act in 2011, first of all, the Data Retention Act, and it talked about you can't be general, you can't be indiscriminate, you can't just go around harvesting people's data. And then it went after, post the Dwyer case, to the European Court, and they said the same thing. They did say there were certain exceptions, though, and that's going to be important, I think. Not only did they say it, but the Supreme Court then said it here. Oh, yeah, you can't harvest, you can't just keep taking data willy-nilly. However, there might be some cases if it was inadvertent or was in good faith. So now what the Court of Criminal Appeal has to do in the case of Dwyer is to just look at that particular case and say, well, how do we apply this kind of messy stuff and make some sense of it here? And that's what the big question is at the moment. How are they going to do it? Are they going to say, agree, oh, yeah, look, there's no generalised way you can harvest people's data. But on the other hand, in this case, maybe you could or maybe you couldn't. We're about to find out.
Because this was the whole thing of this, and why he was convicted was because what the data they found on phones that was linked to him. Well,
yes, it was. But of course, the prosecution would say something different. So Sean Gearan is saying, no, it is important. However, we have enough DNA evidence, enough scientific evidence. And do you remember he said this thing about good old-fashioned police work in Blackrock Garda Station? So, well, you would say the prosecution would say that, wouldn't they? But that's what they are saying. And by the way, the defence aren't just talking about retention. They're also talking, by the way, in smaller points about the way the judge might have looked at the defendant and or jury. He was scowling, and there was stuff about video evidence.
Yeah,
so they're backing everything up.
The way the judge looked at him.
Yeah, well, I was there now for the whole trial, and I don't remember that. Maybe I should have been looking out for it, but I certainly don't remember the judge, Tony Hunt, scowling at anybody particularly.
So they're saying as though he was biased already.
Yeah, that's what they're saying. I mean, to me, that just sounds like, people don't go, lawyers don't go in with just one big argument. They go in with one big argument, and here's a few more I prepared earlier. And they're both doing it, which is,
At the time, I remember people looking in at this case globally, because obviously it was about, using WhatsApps, using everything. And then we'd heard one of the biggest true crime cases that put podcasts on the map was Serial, about Adnan Syed and the pinging of mobile phone data. That's where I'd kind of heard about it. And they were using this again in the Graham Dwyer case. Is he appealing, saying, you shouldn't have been able to retain my data, or is he saying, I didn't do it?
Oh, no, he's appealing. The data is the issue.
The data is the issue. They shouldn't have been able... The data is the issue.
I mean, by the way, he may be saying he didn't do it, but,
But that's not being brought up.
They're saying this data should not have been used. So, I mean, the issue is now what's going to happen? I mean, what's going to happen? Is he going to walk in 3 months, 4 months' time when the verdict is given by the courts? There are a number of options, right? So he could potentially walk. They could say this data should not have been used.
And he'd be allowed, he'd be a free man that day.
If that happens, that's it. He's a free man. The conviction would be quashed. I think that's unlikely. I'll go a bit further. I think that's very unlikely. On the other hand, they could say, well, listen, what we need here is, we take the Supreme Court's point, we take the European Court's point, we have to, about this general data retention, and it is a very strong point, and what we need now is to quash it, but let's have a retrial. So a retrial, I think, is a significant possibility where they will ask that court to see if they'll allow the evidence in or not with regard to mobile data and location and so on.
Could they say that, OK, you shouldn't have used this data in the original trial, but we still
have the DNA, and we still have all the other stuff?
No, absolutely. And you know what? If I was a betting man, I'd probably side more on that interpretation, that they'll say, shouldn't have done it, bold people, bad people, let's never do it again. You know what Europe has said, you know what the Supreme Court has said, But you know what? Yes, that detective work in Blackrock that Sean Gearan talks about, that DNA and scientific evidence that Sean Gearan and his team talk about, that's good enough for us. The conviction stands.
And like, he was convicted in 2015. Why are we only having the appeal now?
Oh, because, well, I mean, normally appeals take a while anyway.
Was it appealed straight away, no?
Yeah, no, I mean, the documents were lodged straight away, but it takes time. And the reason it takes time, of course, is this has been going all over the houses. Most unusually, it went to Europe, it's gone to the Supreme Court, and now it's back again down to the criminal court. Now, normally you see the logic is it goes up from the Court of Criminal Appeal to the Supreme Court, but circumvented off to Europe, back down to the Supreme. Supreme Court have said what they wanted to say, no generalised use. However, there are circumstances when you can, in the interest of justice, blah, blah. And now it's back down again. So it's taken a long time primarily because of the way it's gone around the houses, if you like.
Wow. Now, obviously, we're for an awful lot of social media and media companies, the Ombudsman is here for Europe because their bases are here in Ireland, right? Does this have a knock-on effect, the retention of data, how guards can use it, with an awful lot of other cases that have happened since Dwyer or even before?
This is really a big issue about it, is. Like, let's say, for example, the court said, no, you can't use it, as the two courts have said. You shouldn't have used it. You're free. Where's that going to leave investigations in this country and arguably elsewhere, who will also be looking at this country? But just stay here for the moment. It could potentially mean the Gardaí would have to be incredibly careful about collecting any sort of phone data at all in any criminal investigation. Now, that's kind of ludicrous, if you think about it. It's ludicrous. The public really wouldn't want that. And this is important because the court takes into account what it calls what's public policy, what's in the interests of justice. And they will look to that you couldn't really have a modern investigation.
Because everybody's using phones.
I mean, if you were to really take this rule right down to its nub point, she'd never look at a phone again. And clearly that's not going to happen.
No,
So they have to carve out something sensible now, which says, you can't just go around taking everybody's data all the time willy-nilly. Fair enough. Most of us would agree with that.
Yeah.
But there will be circumstances, individual case circumstances, where you can, and this is how it operates.
Yeah, and like, obviously, like, if it's a murder investigation and there's the circumstances. If you're can anyone appeal their conviction?
Oh, everyone can appeal. I mean, whether they're going to be successful or not's another matter.
If you're found guilty, we could just say, I'm going to appeal that.
You can't. Doesn't mean it'll be accepted, but you can appeal in a point of law, you can appeal as to sentencing and so on. But it's not just, just throw in and I'll appeal. Like, it's quite a serious matter.
Yeah.
It doesn't mean your appeal will be successful. But if it's a significant point of law, it's going to find its way up to the Supreme Court, who, by the way, will only look at it once. So they ain't going back again to revisit this. This is now with the Court of Criminal Appeal, and here it will fall.
Because it does feel like you don't want to have your privacy completely and utterly invaded by the Gardaí any single time that they want to.
No.
But is there a thing that can be done in law where you're like, when something is as serious as a murder or, a child gone or someone gone missing, that there has to be, but it has to be one...
Yeah, but that's a good point, because that's really what the European Court are saying. They're saying there might be certain person or persons, certain geographical locations, as long as there's a thing called independent oversight. Now, we don't quite know what all of that kind of means, but it's a guideline for us. And the Supreme Court here isn't agreeing too much with that. They just use different words. Inadvertence, it must be good faith. But the Court of Criminal Appeal will decide on the Dwyer case. Yeah. We're still left with the Supreme Court and Europe. And now what the legislature needs to do is tidy it up a bit.
So what do you see happening?
Well, my own guess on this is that, as Muireann says that I think what's going to happen is they're going to say shouldn't have happened, and they'll give a number of reasons why it shouldn't have happened. Why did you do it? But, however, in the circumstances, we think there's enough evidence there. I think that's the most likely.
But it won't be a retrial. He will lose the appeal.
You cannot rule out a quash conviction and a retrial. But as regards him walking on the day of, no, I think that's very unlikely.
How long will the decision?
Oh, we're going to be talking about a few months. They've already indicated that, so we may wait till after Christmas. Yeah.
Right. Okay. Wow. Thank you so much, John Deane-O'Keefe, forensic psychologist. Thank you so much for joining us.
Thank you.
Cheers.